goes to court, then that's when I pass it off to one of my much more aggressive partners who can represent the client's interests before the judge. But I work with businesses kind of all sizes. I work with kind of everyone from startups all the way through, even multinational companies, and kind of issues that come up from inception through really the lifespan of the business. So all the way kind of through the ultimate sale or exit. And about half of that work is kind of M&A deal type work. So people buying or selling a business, selling their business, or investing in a business. And then just kind of, the day-to-day issues like strategic planning, some contract negotiation, joint ventures, that sort of thing.
What sort of work makes you excited?
The deal work is always exciting because it's pretty fast-paced and it's, kind of gets the adrenaline going. It's also like all-consuming, and so it's hard to do anything else. So I like it in, I'm glad that's not all of what I do, but that's probably the most exciting. But even just working with startups like you guys, it's just exciting to work with people that are just so enthusiastic about their ideas. And it's always a fun group, and just learning about kind of new products and markets and things like that. So great question. The goal for me is to kind of hopefully not talk at you for the next 30 minutes or so, but just to try to give you some practical advice here. I want to kind of help tune your own antenna to spot these issues as they come up or as your business is developing, and know when to call in help when you need it. And obviously, one of the biggest benefits of an incubator like Surge is the community and shared experiences. So I do, and certainly, like, if you guys have any messes or personal stories that you want to share that are relevant, please feel free to speak up along the way here. So with that, I'll jump in to kind of the first way to mess up, and it's relying on a vague understanding among your co-founders. This is always a hard conversation to have among co-founders because no one really wants to talk about who gets to make the ultimate decision, or who gets to make more money potentially, who has the bigger stake in the company. But it's way easier to have that conversation up front before it actually a problem arises, or you're trying to sell the business or make a material change to the business. Before to deal with that up front rather than wait until the problem comes up. We run into this a lot of time where it's kind of operated on a handshake, or it's a couple of friends that started the business and they get along really well until one feels like he's being treated inequitably for one reason or another, and without something in writing, that can become a big problem. So it's really important, especially to start with a good operating agreement or shareholder agreement, or depending on the type of entity that you are, to get that in writing up front. And you're going to document things like who owns what part of the company and how are decisions made, both kind of big key decisions like when do we sell the company or take on new owners, and even from the day-to-day decisions like should we hire this person, or should we expand into this market, that sort of thing. All of that is usually delineated in the operating agreement itself, and again, getting out in front of that avoids kind of an impasse later on where you have to make a decision and you can't do it. Things like how much are the founders going to be paid, compensation, both from a compensation standpoint and distributions. If your business is making money, how are you splitting those profits up? If a founder quits or just doesn't want to do it anymore, how do you handle that? Can you automatically buy back their equity? Usually you at least want that right. We'll talk about kind of vesting and how much equity the person actually has at that time. But the point is that clarity is good for everyone. This is kind of a dated reference at this point. I've given this presentation before, but this is a Facebook reference. And if you've seen the movie The Social Network, it goes into a lot about the disputes with these guys who claim to have invented Facebook. But this was a problem that was $1 million issue, not to mention a lawsuit that could have been avoided, had they kind of put it in writing up front. If you don't have an operating agreement, so that's, again, this is for an LLC or depending on the context, but if you don't have one, the state will provide one for you, so that's given under statute. And this is an important reason to put it in, to have one, because the state says, or the Michigan LLC Act would say, all members own the company equally. All members have equal voting rights. And so kind of regardless of what you talked about, maybe when you brought on another owner, if it was just like a conversation, that opens you up to disputes later with the other owner saying, well, wait a minute, no, I was supposed to be an equal partner, or I was supposed to have these same voting rights. And so that's the default that you fall into if you don't handle it up front. You want to talk about things like time commitments, sorry, I'm trying to get to vesting.
Do you ever have that happen
Yeah.
where it actually works just fine?
Where they don't, like the default?
Mm-hmm.
Sometimes, yeah. I mean, it obviously depends all on the personalities of the people involved, right, in their relationship.
Mm-hmm.
It's rare, not for it to work out, but it's rare for there to be nothing in place at all.
Yeah.
But that's really just meant to be kind of the backstop. So if you form an LLC and you don't have an operating agreement, those are the default rules.
If it goes well, no one's telling a lawyer.
Yeah.
Exactly, yeah.
If it's working,
Yeah,
it's
exactly.
close.
We say we live on the dark side of the moon where everything that can go wrong does go wrong. So that's just the world we live in, yep. Another way to mess up is to kind of promise everyone equity or give away equity, kind of willy-nilly. Obviously, not everyone's gonna have the same commitment to the business. People are gonna get bored, and really this applies to founders, to key employees, even investors. I mean, you just want to think carefully about what portion of the company are you giving away in exchange for this person's services or expertise maybe, and how should that tie to should they get all of that equity up front? Should it vest over time? What portion of the equity should they actually get? And so there's no easy way, and it really does vary on a case-by-case basis, but there's no right answer as to how the equity should be divided, and we get that question a lot. It's just a really hard question to answer, but there's a lot of factors that question should take into account, including obviously the value of any kind of contributions the founders are making, whether that's a cash contribution or particular IP that they own. The founders or the investors' continued participation in the business. How long is that? What does that look like? You want to think about control over decision making. Obviously, we talked about these different types of decisions that are made on a day-to-day basis or on a long-term basis. And the equity doesn't always tie to that decision making, but it usually does. And I can talk about that distinction in a minute here. As startups, I'm sure you guys are very familiar with the concept of vesting, but in broad terms, it's saying here's some equity. It's restricted, whether it's restricted stock or stock options or restricted, LLC units, but it's not full-blown equity. It's equity that has strings attached, and maybe you get a portion of it up front, and then it vests over time. So, a lot of times there's like a 4-year period where you have to remain engaged with the company, and maybe you're getting it in installments, sometimes it's equal installments, like year by year, as you stay with the company. Sometimes there's like, a cliff where you have to wait until the very end of that term, whether it's 2, 3, 4 years until that vests. But that gives, the founder or the executive, whoever's getting the equity, it gives them incentive to, stay involved in the business, obviously. And at the same time, on the flip side, if they don't stay involved in the business, they don't automatically continue to own, 25%, 50%, whatever it is, of the company. So this is like a key term especially for startups, and especially for, individual founders that, again, with starting off with the best of intentions, but maybe don't, their lives change and, circumstances change, and maybe they just don't have the ability or desire to continue in the business going forward. So,
Question.
yeah.
When equity is vesting, are you amending the operating agreement or every single time that it does vest, or?
Usually you would do that up front. So when the operating agreement's put in place, the operating agreement usually will have like a static number of like, here's how the company's owned.
But for like the third partner or whatever that comes in 2 years later, that's gonna be on a vesting schedule.
Mm-hmm.
Every year, if it does vest, would he then just get that portion, and we would actually amend the agreement every single time, or?
Yeah, usually you wouldn't have to amend it every single time.
Okay.
Usually the operating agreement stays in place, and so there's some language that kind of allows for automatic updates in that case. There would be a separate vesting agreement or restricted stock agreement or something else along those lines that goes into the terms of how the vesting happens.
Mhm.
But it's not like you have to then go back. Usually there's language in the operating agreement that says we can update this member schedule, as needed, without a full-blown amendment, if that makes sense. Good question. So there's a lot of different ways that vesting can occur, but usually it's some kind of time-based option, like I said, or maybe it's milestone-based. Maybe it's based on when we get the product to like MVP stage, where it's actually like a viable product. There's a lot of different kind of customized options that you can use. But it's tied to some kind of milestone or time period. And I've listed some, I talked about some of these types of equity equivalents, or, vested, or unvested equity, I should say, restricted stock units. There's a few different terms for those. Stock options is another one that, you're allowed to buy stock, but only in pieces over time as these milestones are achieved. Phantom equity is a little bit of a different animal. That's where you don't actually have equity in the company, but you get to share in the profits of the company. There's kind of pros and cons of that, and I'm happy to answer questions on, but that's another potential option.
What are the pros and cons of that?
So, the pros, it depends on what side you're on. The phantom equity holder is not going to have voting rights.
Right.
They're also, that equity is subject to like redemption, like the company can call it back easier. And it's good for the company because of that, obviously.
It's like profit share, but without equity.
Yeah. Yep. That's exactly right.
That makes sense.
Yep. That's a good way to put it. Obviously, there's a lot of good reasons to grant equity. I'm not trying to talk you out of granting equity at all, but it's great for attracting employees. A lot of times that's a key part of a compensation package for executives that you bring in. Incentivizing performance, like similar to a bonus. Aligning interests, obviously, both with founders and investors. And at the end here, obviously it motivates the board and the directors to protect the long-term business, because those directors are, have a personal interest in the company's, success going forward, because, in this case, the directors would have unvested equity that ratchets up over time. I keep pushing the wrong button here, sorry. The next way to mess up your start, and again, please jump in whenever you have questions. I want to talk about IP a little bit. Obviously, you know, IP, depending on your business, sometimes it's more important for certain businesses than others, but sometimes it's really the whole business. And probably the first thing you should look at is doing some due diligence, you know, not only on kind of the type of product and its functions, but, you know, specifically the name of your company and maybe the name of the product that you want to use. You know, these are all methods that, you know, you can do on your own that we could help, you know, any lawyer could help you with, but doing some internet research, the state of Michigan has a database of businesses that if you're not familiar with, it's good to at least know about. If you just Google Michigan business entity search, or really for any state, the Secretary of State of each state maintains this list of all businesses. You can see what exists and what names are out there. Are there any potential conflicts? You want to think about it on both the state and the national level. So USPTO, that refers to the Patent and Trademark Office at the federal level. That's also a publicly available domain and kind of database that you can search. And then domain name registrars, you know, that applies more to the website, the URL itself, but that's another publicly available database that you can search. I threw in a couple of these trademark or copyright symbols just because I find them kind of interesting as a nerdy law geek, but just for your reference, the R means it's an actual registered trademark with the Patent and Trade Office. The small trademark sign or the service mark sign, really anyone can use that. It doesn't mean anything from a legal perspective except that it indicates to the marketplace that that's a mark that you're claiming kind of rights over and using in commerce. And so, and you know, that can vary, and sometimes it's not obvious that you know, your actual term is a trademark. So that's something that can be used regardless of whether the mark is registered. This applies to copyright, which is more, you know, a lot more broad than just a trademark or a symbol or a logo. It applies to writings in general, music, publishings, you know, a broad category. Did you have a question?
Yeah, so if you do register, like we're in the process of registering our brand name.
Yep.
We found other people are starting to use it in places that we don't want them to. So we're registering it, but then do we have to put that little like bar and circle around it in certain places for it to be like real, or like what is that? Like what's the?
Not for it to be real, but I think that, I mean, we would recommend it just because it does it puts people on notice that it's registered.
Okay.
And so and therefore kind of gives you some more protection.
And then you're able to ask people to like stop using your brand name also?
Yeah, yep, and that probably requires a little bit of a deeper dive because, you know, there's limits on, you know, kind of the geographic area that you're using it or how you're using it in commerce, and, you know, is there like a likelihood of confusion? But yeah, that's definitely one of the considerations.
Is it recommended to register your company name in a way like that, and which one's most appropriate for that?
I think maybe, but probably not in all cases, but yeah, I think that could be useful, you know, for you guys that, you know, it's kind of a unique name. You have to think a little bit about, you know, how likely is it, you know, that someone else is going to use this or use like a derivative of this. But yeah, I think a lot of times we would probably recommend that. You know, like anything else, it's kind of have to prioritize, you know, your own like legal needs and like what's the most important. But yeah, I think that you know, if you talk to one of my IP partners, I think they would say, yeah, definitely, you know, that's recommended if, you know, not just because we're trying to sell legal fee, you know, sell billable hours, but it'd be, you know, I hesitate only a little bit because it's a little bit outside of my wheelhouse in terms of pure IP, but I think in general it's a good idea, especially if you have a distinctive name or something that's likely to be copied.
Question.
Yeah.
For the TM, I know you can just slap that on anything, and it's really helpful because that's free. But if our logo is in the market with a TM for long enough, does that give us some sort of place in the market?
Yeah, good question. Yeah, it does. It's not as broad as having a registered mark because
Mhm.
that kind of puts people across the country on notice. But using the mark, especially with this TM symbol in commerce, gives you protection, and there's like a first in time type
Mhm.
right where, you know, if you're doing that before others,
Mhm.
then you have some automatic protections. Now it's a little bit limited, like
Yeah.
depending on like the geographic area that you're using it in.
Mhm.
So it's not quite as broad, but yeah, I think that's, yeah, yep. Does that answer your question?
Yeah.
Obviously, NDAs, confidentiality agreements, these are more broad than just IP, but that's a lot of what startups are thinking about. These are, you know, recommended kind of across the board. I think it can be a little easy to be a little too kind of trigger happy with these, and depending on who you're talking to, you might want to exercise a little bit of caution. Especially with investors, I guess I would tread a little bit cautiously. I think you probably want an NDA in place, especially if they're doing some extensive diligence. But sometimes investors might be kind of turned off, like if you like they're talking to dozens of startups on a weekly basis, and just I say that because it's fresh in my mind from a recent client issue, but just keep that in mind, I guess. But it's still good to have a form that you trust, and that especially if you're talking to having developed conversations with investors or other potential founders or employees, it's great to have those in place. Establishing ownership of the IP is another big issue, and that raises a few considerations. So one, I'll talk about independent contractors, but especially where a contractor is performing services that will contribute to the company and add to the value of the company, it's important to have an assignment or kind of a work for hire type term that makes clear that they're doing these rights for the company, and the company will own everything that comes out of that. And that the risk is that without it, it can be a gray area. And so I could tell you a half dozen different stories where this has come up, but it's a lot more clear where it's an employee developing the IP as opposed to a contractor. So with employee, it's like the default is that the company owns it, and that's not true for outside contractors. Similarly, if you don't have that up front, it might be something that when you sell the company or you're have someone looking to invest, they're like, who's this person that's listed on this patent, or that was involved in the creation in some way. Sometimes you actually have to go back, even if it's been some years since the person was even involved. Sometimes the investor will actually require you to go back to that person and get like a formal assignment, and that can cause issues in and of itself, where that individual realizes they might have some leverage here, and that maybe there's some dollars at stake, and they try to try to hold you hostage a little bit.
I think there's two spots where that kind of comes up. Like one, if your name is on the patent, and then like, let's say I'm working with a dealer, like it's our patent, we manufacture something, and let's say you want to sell my product for me. In our agreement, I'll put any ideas you have to improve the product, or any ideas you have that relate to the patent. They're owned by me, like thank you for that helpful, but we're going to give you better product to sell. But you write that,
Right.
you delineate that in any agreements you'll have, so that way no one's like, hey, I told you to make it orange, I'm now part owner of your IP. And you're like, no, you have to have that line in there specifically.
Yeah.
I-
Yeah, good point.
So I
Yeah.
know you said you need to make sure in the agreement, if you're hiring a contractor to develop IP, you need to write it down, but what if you don't know what you're going to develop together? What if you set out to do one thing and then another thing evolves? What's the jargon to cover yourself for that?
Well, I think you'd want it probably kind of as broad as possible, and usually the language is drafted in that way. I think it's just a matter of setting the expectations with the contractor or whomever it is up front. Usually the contractor is going into that not expecting to own anything, but it's not always the case, but that's usually the case. And it's really just, it's, you know, referenced as like a work for hire type paragraph, but it defines the you know, whether it's the product or the services being performed, it defines that really broadly to say, you know, everything, all the deliverables that you give me in any kind of derivative product or, you know, similar intellectual property rights that you create in that context, and I'm paraphrasing a little bit here, but that language would intentionally give you, the company, the broadest rights possible to maintain those protections.
We've done something like any ideas or new products or developments or improvements upon like our suite of products will remain ownership of, you know, our company. But I don't know how like enforceable that is.
Yeah,
Yeah,
I think that's it right along the same lines.
Yeah.
Does that make sense? Yeah.
So in the same vein, if you have somebody doing like copywriting for you for like social media or marketing, could you have an agreement that you own that and they can't use that for other clients or their
Yeah.
own purposes?
Yep, great point. Yeah, and I think that, you know, like sometimes this is just considered boilerplate in any kind of, you know, independent contractor agreement. But yeah, that's usually something that, you know, ideally is specifically called out. A lot of times that's probably read into, you know, some of this more broad language, but usually you'd want that clear, if only so they can't just use the exact same content for somebody else. But yeah, that's a good example. Any other IP questions? Otherwise, obviously we can come back.
I had an
Yeah.
experience with this, maybe just as like a be aware of thing for other founders, is that we recently were working with a hard tech accelerator, and we were sort of operating on this like, yeah, we're gonna be participating in their like learning course, and then there was this small grant of services that they would give us afterward, and they were like, you know, weeks into like, you know, developing some CAD and like 3D, you know, printing sort of like improvements upon a design that we had talked about and brought in with all this background information. And then I reached out and I was like, hey, just to make sure and put my mind at ease, is there an agreement that makes me feel like we have all of the IP that, you know, I just wanna see the agreement because I haven't seen it yet. And they sent one, they're like, yeah, sure, this is our standard agreement. And it was just like red flags all over the place. Like they, even though they were like an economic development agency, they're like, we own the IP, we'll grant you a license, you can't transfer your license to anyone else. And I was like, whoa, like, and it said in there, like, by the way, just accepting any services from us is automatic acceptance of this agreement. I was like, no. So, I was like, all right, maybe I'm just being pessimistic about this. I reached out to somebody and they're a contract attorney, and they read over it and talked to me yesterday. He's like, I have done operating agreements and contracts for like Apple, and this is way more onerous than that. This is way worse, and like this is like not what an economic development agency should be like giving a startup without like functioning capital. It's like totally predatory. They're probably not meaning for it to be. Like it's probably just some lawyer wrote it up and they don't know how bad it is, or like for some other reason, like I'm still giving them the benefit of the doubt, and they've been like, yeah, sure, feel free to redline it and send back any requirements and we'll do our best to agree to it. And I'm like, that's great, but it just like, you can't assume that it's gonna be kosher, even if it's like entrepreneurial support help.
Wow.
Yeah. That also goes for employees. So as an entrepreneur, I've still had to have moments of my life where I've had to take on a W-2 job, and they sent me a non-compete brouhaha thing that was like they own everything I've ever done. It was like
Yes,
I just
yes.
like crossed all out. I'm like, I'm not signing this. They ended up firing me, but I didn't. I mean, I think we're all here. You know, we're entrepreneurs because we have a problem with authority, right?
Right.
So it was never going to work out. But yeah, that's just something to keep on top of if an employer ever throws that at you, just say no.
Yeah.
It's not you, it's me.
Right, exactly.
Yes, exactly.
All right, I'll move on to the next one here. We see this a lot, relying on do-it-yourself incorporation, and sometimes, frankly, it does work out okay, especially where it's just you. If it's a single owner and you're not dealing with an investor or a co-founder, it's probably difficult to mess it up too bad where you're forming your own company. And there's enough kind of resources online, and I think the state, Michigan itself, kind of gives you some direction on how to do that. But there's some bigger questions involved even in that process, where you're thinking about what type of entity should it be. These are I'm sure you've heard of all of these, but a couple of different types of corporations, whether it's a C corporation or S, a limited liability company, partnerships. Sole proprietorships are what you do if you don't have any business entity at all. It's really just you, so you're personally liable for all of the businesses, any kind of claims or damages or profits and losses of the business. That's definitely you want to avoid that at all costs. Partnership, you don't really hear about partnerships too often. It's more of a kind of dated historical company, and that's entity type, and that's because there's not any liability protection from a partnership. You're still kind of personally liable for your share of the partnership. Limited liability company, or LLC, is by far the most common, and really that's what we would say, unless you have a good reason not to do an LLC, that's the form that you should do. There's a few instances where it does make sense to be a corporation, but especially for most startups, an LLC is usually the best option. But it depends on kind of how far down the path you are in your fundraising or product development, how mature your business is, because the corporation is, again, not required, and there's kind of some drawbacks of having it set up as a corporation, specifically double taxation. That's the big one you hear about. Profits that come into the company are taxed at the corporate level, and then when you get the money distributed out to you as an owner, then you have to pay tax on those exact same profits. The LLC avoids that scenario, and frankly the S corporation avoids that too, but I'm not going to get too deep into tax law right now, but feel free to ask any questions. The LLC is by far, when we're forming an entity, 95% of the time it's going to be an LLC. With that said, the corporation, this is a slide ahead, but the corporation is sometimes preferred by institutional investors or venture capital folks. Private equity sometimes looking for a corporation, specifically a Delaware corporation, because that's the form, that's just the form of company that they know. That's the form, frankly, that their lawyers are familiar with. Delaware law is by far kind of the most sophisticated and kind of cutting edge of all kind of corporate law in the country, and they make it a point to kind of stay and maintain that position. So there are instances where it makes more sense to form as a corporation, or maybe you can convert your LLC to a corporation as well if it's already formed.
Would there be any reason to do a out-of-state entity for sales tax savings, or does it get negligible with costs?
Good question. Sometimes, yep, and that can be kind of a complicated analysis because it really depends on like where you're doing business and where you're selling the product. So, you know, you being here in Michigan, for example, you couldn't necessarily avoid Michigan sales tax just because you formed the company in a different state.
Mhm.
You'll have to, and actually I'll jump ahead. Well, I will jump ahead, but there is, you can register, you might have to register in both places in that case. So it's possible. Usually it's difficult to kind of play games like that unless you have like a actual tie to that state or a reason to not form in Michigan.
We have some growth to go. We're an LLC taxed as an S corp, and that's been really tax optimized.
Yeah,
Yeah.
and so the benefit of that is that you get to avoid the self-employment tax, right? And so it does save you on some taxes when there's a couple, there's some rules you need to follow to maintain that status, but
Yeah.
yep, that is the big benefit. Let's talk about, so regardless of what entity type you have, you want to make sure that that the entity exists, and then that you're following these kind of so-called corporate formalities. Maybe you've heard of this term, piercing the corporate veil, and that's where a company's creditors can say, well, I know I had a contract with you, business, or XYZ company, but this is just a shell, it's just a front for, you founder individually, and therefore I want to, I have a judgment against the company, but I want to enforce that judgment against you personally, your own house, your own personal assets. And that's a risk for any company really, but you protect against that by following some of these corporate formalities or these kind of specific rules to keep the business distinct from your own kind of personal life and finances. This is not really a definitive list, but the biggest ones are maintaining separate bank accounts. Obviously you want to have your company have its own bank account, its own books and records, not intertwined with your own kind of personal payments. You're paying, separate taxes. You're doing business under the actual corporate name, and part of that is signing contracts as the company and not, just signing your own name. Which can be ambiguous. Did you sign it in your individual capacity or as an owner of the business? I included this signature block. This is not the end all be all, but this is one way to really make that clear. With the company name, you sign it, and then, usually it's printing your name underneath with the title, whether it's I'm the manager or president or whatever it might be.
Is that for anything?
Any type of company.
Or any type of document that you would sign for the company? You're saying to sign
For,
it as
pretty
the
much.
company?
Yep. Yeah, I think almost in every case. I hesitate a little bit because you don't need to be like super formal when you're like signing a letter on that, an employment offer or something. Usually it's kind of obvious if it's on employment in the company letterhead or something like that. But by and large, I think you'd want to make that clear, just so the other party knows, and then when people or a court is looking at this 5 years from now, it's very clear that the company is the party and the company's obligated as opposed to you personally, if that makes sense. Obviously the main goal here is limiting personal liability. Again, we talked about these different entity types and how really, if you want to do that, it needs to be a corporation or a limited liability company. But it's not a bulletproof shield, but it's kind of as best as in terms of your own personal stake. You're still responsible for your own negligence, for example. Like if you injure somebody, if you, knock over a pitcher of water and someone slips on that, they could, and it happened here, they could maybe sue you personally and, whether it's Surge or, the owner of the building. So you're not totally off the hook, but for any kind of contractual liability or, major, if the company's creditors are, chasing money, that's where it protects you. This is another dated reference, but I just laugh every time I see this. This is not how you declare bankruptcy, just to any Office fans out there. We talked a little bit about where to incorporate. Oftentimes we're working with people who incorporate in Michigan or Delaware. Delaware, again, is if you're anticipating raising funds from, especially venture capital or sophisticated investors in the near term, meaning in the next like 12 to 18 months perhaps, or maybe you're talking sooner than that. Sometimes they'll require it to be in Delaware, or you can. They might require you to convert your Michigan entity to a Delaware entity at that time. Not always, but sometimes the Michigan entity is fine. Oftentimes it is, I would say. But those are the two of the states that we deal with most frequently. There's a way for, we talked about where you're doing business, specifically in which states. As a Michigan company or Delaware or wherever you're formed, for that matter, if you're doing business and it rises above a certain threshold, depending on the state's laws, you might also have to have that business registered as a foreign entity in those other states. So you could be a Michigan entity registered to do business in Indiana or Florida or California. It relates to kind of the sales tax question a little bit, but that's not the sole kind of determining factor. But usually if you're conducting significant business, or if you have a warehouse that you own in a different, or lease in a different state, a lot of times that will trigger these foreign registrations. They're not difficult, they're easy to do, but it's just a simple filing that you have to be aware of and complete with that particular state.
So you have to file as a business in those states as well as doing the sales tax? Is it separate?
Not necessarily. It is a different criteria. That's where it gets a little bit complicated, but.
If you don't have economic nexus, but you're selling into a state, you still have to do that?
The economic nexus test is for sales tax.
Yeah.
I think usually that would kind of push you above that, doing business in the state. It's not 100%, but usually that would be the same,
So like digital selling, you don't have to be registered in the state to sell digitally in the state.
I don't know that I can answer. I know enough about that tax piece to be dangerous, but I definitely would want to
Well, are you
Calling
selling a
it.
physical product?
No.
Okay, yeah, I don't know how that works.
Or playing, but I follow
Yeah.
as much as I can with the limited resources we have.
I know, there was a big case just a few years ago involving Wayfair that it really set the
That's
rule for
really
that.
messing us up. We're following Wayfair, but I want to quote you all the details, it's a mess.
Yeah, it is. Every time that comes up, I'm always happy to pull in my tax partner to handle it, because you probably don't, I'm not fully qualified to give that advice, but happy to talk offline afterwards. I say be wary of these standard agreements or kind of chat GPT agreements. Often, like I said, a lot of times if it's just you, and especially if you're the only owner, we're talking about an operating agreement, it's pretty hard to mess that up, because it's not like it's not like the company is gonna sue you for something in the operating agreement, because you're on both sides of it. So I think there's really pretty low risk if you're like a single member entity. It gets more complicated where, like I said, where you're having another founder and you're arguing about distribution rights or control rights, that sort of thing. There you can find a lot of examples online, and some are a lot better than others. But you just have to be careful, and it can be great for kind of background research, and to kind of give you an idea of what's out there or what other companies or competitors are doing. But you really want to make sure that it's specifically tailored to your particular business, and that can be a hard determination to make because of the legalese that you find in a lot of contracts, and it's hard to kind of understand what it even is saying. So just a word of caution, I guess. Kind of the bigger problem not only from like an enforceability or, you know, ambiguity standpoint, is when it has an impact on your company's valuation, and you know, maybe the foundation of your company is like cracked or off for some reason because of like unusual terms in your document, and then, you know, it impacts your ability to raise money potentially. So that, and I know that probably sounds like just a plug for like legal services and you're hiring an attorney. It's just more just to be careful, and, you know, if it's something like where it's real dollars are at stake, like I would caution against using, you know, a form agreement, or, you know, AI is getting better and better every day. Ask me again what that looks like in a couple of years. Maybe you can do something like that, but at this point it's not there. And it's not as easy as just finding a document and like changing the names and the dates. It's just, it's almost never quite that simple. It's just, you know, that's why lawyers exist at all, is because if it was that easy, then anybody could do it. So.
Quick question about that.
Yeah.
So if you were to write an operating agreement or any type of agreement like that, where would you source the material to tailor it for a certain type of company?
So, you know, that we have like kind of obviously a database of like agreements that we've done in the past.
Mm-hmm.
We also, you know, we have a subscription to like, you know, legal, it's called this Practical Law under Westlaw, that provides a lot of, you know, really kind of technical lawyer focused documents and, you know, subject matter materials and stuff like that. But that's where we would pull from, but also just kind of, you know, years of experience and kind of working with clients in similar circumstances and that sort of thing. So not to say that, you know, any law firm is like the gatekeeper of like the best documents or anything, but, you know, that's where kind of some of those efficiencies kind of come into play, where we've like done it before and we can, you know, pull from standard templates that we might have or outside sources like that.
Question.
Yeah.
We have a new company forming, and an operating agreement was made with a pro bono lawyer, and it's 42 pages long. I hate reading it. I'd love for it to be shorter, but is there anything wrong with a really long operating agreement that's just really
Not in
repetitive?
itself, and that's not unheard of. That's probably kind of overkill for what you need.
We're not doing anything fancy over, yeah.
Yeah, you know, usually they're closer to, they're still long, but
Yeah.
usually they're closer to like 20, 25 pages.
Okay.
You know, sometimes they can be like 100 pages if it's like, you know, if you want to make it super complicated or there's a lot of money at stake.
Mm-hmm.
But, you know, I would say just by the fact that it's that long, I don't think that's a reason in
Okay.
itself to start from scratch
Like
or
an
to get a
investor
new
would
one.
look at that and be like, huh?
No.
You guys are
Okay.
morons.
No,
Yeah.
I don't think so. Right, yeah.
Repetitiveness.
I don't think so at all.
Just make sure to read it and make sure there's no gotchas in there. And
Yeah, I think that's right. Yeah, I guess you want to make sure
I
that.
might want another lawyer to look at it.
Right. Yeah, it's hard because there's really only like a couple of articles that even in that in that operating agreement that are really the most relevant.
yeah.
And it's stuff like, well, for one, how's the company owned?
Mhm.
How are decisions made? And what restrictions are there on your ability to transfer the equity itself?
Gotcha.
And then there's going to be a whole lot, like probably 10 plus pages in that agreement that's all tax related, and it's
Yeah.
all like, you know, how profits and losses are allocated from a tax perspective between the members, and
Okay.
you know, frankly, that's language that rarely changes between companies at all. So
Mhm.
it's kind of as close to boilerplate as you can get, depending on the company's particular tax situation. But those kind of three categories are probably the most important.
So you said equity, restrictions of transferring equity, and what else?
And decision making.
Yeah.
Yep. Sometimes it's as simple as a paragraph where it's like any decision, you know, the manager makes all decisions, or you need a majority of the members, or maybe a super majority, or, you know, unanimous members to make the decision.
Yeah.
Sometimes it gets more nuanced where it's like the manager runs the day-to-day business, and then the manager can do anything except if it's on this list, whether it's this, you know, sometimes it's a list of 5, 10, 15 things,
Yeah.
the manager can't take these actions without the approval of some other body, you know, a majority of the member. And then those are the kind of the big items, but anyway.
Is there anything wrong with a supermajority? Is that, I think it's 70%.
No, I don't think so.
Yeah.
Usually, you know, it depends on how many owners you have and how the equity's split up. And the specific decisions that you're talking about, because you don't want to get all of their consent necessarily for you, especially day-to-day stuff. But no, there's nothing kind of inherently wrong in that, and that's, you know, a concept that we would use pretty frequently, so.
So,
Sorry, I'm timed out here. Did the TV turn off, maybe? I could continue without my slides, but I actually built in like some animations and things that I don't want to waste.
There we go.
All right. There we go. I'm almost done. All right. So those are the big ones. Now I've got kind of a lightning round of bonus ways to mess up. First one being securities laws. This is one that really no one likes to talk about. Even a lot of lawyers don't like to talk about this. But when you're issuing equity in any kind of company, that issuance is something that is, the rule is, unless there's an exemption, that has to be registered with the SEC. And so even for a public or private company, it has to be registered. There's a lot of exemptions to that, but that's the default rule. But it's a pretty technical area. And so when whether you're raising money, you know, I think even from the seed round, I think you want to be cautious about raising money from friends and family even, because they need to fit one of these particular exemptions. The biggest one is what's called an accredited investor, and that's kind of someone with like a high net worth or, you know, earnings over a certain threshold over a period of time. It's a defined term. That's a common exemption. There's also an exemption for if you're just offering like within the state of Michigan, that is exempt, at least at the state level. Usually that's exempt at the federal level as well. But it's just something to be wary of. And again, this is difficult because a lot of times startups don't really have the funds to kind of spend money on a lawyer to investigate this. But there's a lot of ways to get tripped up when you're issuing equity, especially where it's, you want to be most cautious where it's like a general solicitation. Like you don't want to put like, you know, a post on Instagram or social media or something like, hey, anyone that wants to invest in this business, just give me a call and I'll take your money. That's kind of the most risky because it's kind of like casting such a broad net that it raises a lot of, that's certainly not exempt. And the specific people that you're talking to have to be exempt, or, you know, either as an accredited investor or one of these other categories. So just be wary of that. There's a lot of information online as well if you want to try to do some of your own research. Terms of service, this is whether, you know, we're talking about a website or, you know, terms and conditions applicable to the services you're providing or products. There are, what you want to be most wary of is making claims that you can't really back up. You know, a lot of times a website will be like, this is the best product in the world, and, you know, there's, you know, we're going to change your life with the, you know, making claims that aren't really legal claims, they're marketing claims, but you always want kind of like that disclaimer, like we're not making, you know, kind of like the boilerplate you see, or like the small font at the bottom of the page, or the promotional materials, whatever it is. You want to just be careful about using that disclaimer that lawyers love to sink their teeth into.
His results may vary, good enough.
That's a start. It's better than nothing. Yeah. But yeah, clearly defining kind of the service that you're providing and the warranties you're making or not making. There's warranties that are implied under the law that if you don't disclaim them outright, and they're like, you've probably seen them, like this is not a warranty of merchantability or fitness for an intended purpose. Those are warranties that are automatically, if you don't say, we're not making these warranties, those are warranties that you are making with your product. And then, you know, sometimes that's fine, sometimes it never results in anything, but it's, you know, a liability to be, a potential liability to be aware of. Tax issues, another one that, you know, again, I as a lawyer don't love talking about and really like to lean on my tax partners for this, but there's a lot of tax issues involved in any kind of startup. I had mentioned the 83B election in particular here. That's something that applies to when you're getting, especially unvested equity. If you are the party getting that equity, there's a way to get a better tax benefit on that equity up front by making a filing with this 83B filing with the IRS. And then when you ultimately sell the equity, you're taxed, you get a tax benefit because you only pay tax on the value when you file that election, when you make that election. So when the, you know, presumably when the equity is worth very little or almost nothing, you're paying tax on that value rather than not doing the filing and then, you know, when the time comes to sell it or, you know, other kind of taxable event, you're paying tax on the whole value, you know, all the growth of that that equity that occurred.
Could you have that
from
with
when
a
you got it.
like phantom equity so that when you do have profit share, it's more tax advantage?
Say that again?
Could you have a 83B election for phantom equity so that way when they do get profit shares, that's the most optimized situation, or is that?
You know, I'm not
something different?
sure offhand if that applies to phantom equity. It's
Okay.
most often done with stock options and
Makes
like
sense.
restricted stock units. Phantom equity, I think that might just be taxed, and don't quote me on this, I think that might just be taxed as like regular compensation,
Okay. Makes
ordinary
sense.
income, yeah. Calling everyone an independent contractor, I touched on this a little bit, but it's not quite that easy to say, hey, you're an independent contractor. There are like a list of factors that are taken into account, depending on the amount of commitment that you're expecting from the person, how much control really you have over their schedule and the work that they're doing. That's one of the biggest parts. And kind of, like I said, you know, the time commitment, do they have other jobs, do they have other clients, that sort of thing. There's like 8 or 9 different factors that we would look at to make that determination, or the IRS would look at. The risk, obviously, is that if it's an employee, you have to have these payroll tax withholdings. You have to kind of be collecting tax or, you know, paying tax on behalf as the employer, and vice versa as the employee, which are not applicable for independent contractors. So everyone, you know, especially in the startup community, you know, kind of I think throws around the independent contractor term a little loose. It's just not, just so you're aware, it's not quite that easy. Usually it probably works, but there are some nuances there. Now we got to figure out this clicker. All right, data privacy. This is a really big topic, and it's something that's grown obviously in the last couple of years. I'm sure you've heard about GDPR in the EU. There's really no nationwide data privacy law here in the US. California and a couple other states have some regimes in place. So it's not a uniform process. I think it'll probably get there in the next few years, and you know, Congress can never talk to one another again. But where you have to be most concerned about it where you're collecting personally identifiable information. So people's names, addresses, credit card info, if your business involves that, then data privacy should be on your radar, especially if you're holding that info. Assume the lawyer represents you personally. Sometimes that's the case. It's not always the case. A lot of times, probably most of the time, the corporation, even if you're a founder, you want to think about, you know, the relationship when you start it with the attorney. But even if you're a founder, you personally, you know, you're interacting with that lawyer kind of as a representative of the company, and the lawyer has the duty, you know, to protect the client, the company's interests, over yours if they're in conflict. Now, the line gets blurry where you really are the company, where you're the only founder, and there's no one else involved. But it's more clear because then it's like there's kind of a distinction without a difference. But if you're, you know, a corporate officer, or, you know, even a founder, one of a few founders, that's just something to keep in mind, because, you know, for one, things that you tell that lawyer, if, you know, things fall apart and, you know, that somehow it becomes a claim that, you know, maybe this founder is actually responsible for, you know, whatever lawsuit's happening or whatever the circumstances, that might not be necessarily confidential, or protected by attorney-client privilege, at least between the lawyer and that person. So just keep that in mind. The lawyer probably represents the company unless you come to a different agreement. Assume all lawyers are the same. I mentioned this only because, like, just like doctors and, you know, healthcare people, there's a lot of different types of lawyers, and they all have different specialties. So I'm like a business and corporate lawyer. That's why, you know, I deal with tax a little bit, but not enough to be an expert in it. I don't, you know, litigate things. I don't do employee benefits. Labor and employment issues are usually kind of more of a specialty. Environmental law, that sort of thing. So don't, you know, I guess be careful about, especially when you're starting out, the lawyer that you're working with. There's a lot, and be especially wary of people who like market themselves as kind of a jack of all trades. Usually that means like, and a master of none is the tail end of that, because there's a lot of, and I don't want to disparage any lawyers, there's a lot of good lawyers out there that do a lot of different things. But just be careful of, you know, you find a website and they do like divorce work, business work, bankruptcy, criminal law, real estate, you know, all across the board. They probably can help you form a company, but, you know, beyond that, you just want to be careful and make sure that you have trust in that person.
What are some of your favorite ways to see if a lawyer is good to trust? Like, do you have to just like cross your fingers on the first, you know, agreement that you work on together, or how do you prove that? Because there's so much confidentiality sort of shielding the results of their work and complexity
Right.
there.
The marketplace speaks for itself in a lot of ways, but yeah, that is a hard question to answer sometimes. You know, sometimes it's just really kind of a personality thing. You know, this is someone that I trust on a personal level and that I would get along with. But, you know, there's ways, you know, there's different kind of lawyer rating services out there. I don't know that clients really use them that often, but that's an option. So it's a hard question to answer. I guess I mentioned this kind of jack of all trades example because I know even in town there's a few people that are good, that know, you know, that are competent and know not to get too far out over their skis or do something that they're not really qualified to do or shouldn't be doing. But there's a lot of people in that category that go the other way, and so I think it's probably most important to be cautious in that space, if that makes
Well,
sense.
what rating services would you recommend?
Martindale Hubble is a big one. There are different, you know, there's the Grand Rapids does their own kind of top lawyers thing. There's like this super lawyers category, there's best lawyers of America. Some of those, you want to look for something that's peer reviewed most primarily, because some of those are just pure like marketing, you know, you can like
they
pay
just
money
pay
to
to
be
be on the
listed.
list, yeah.
Yeah.
Well, so specifically for you, I think you could do what I did, because I worked as a consultant before, well, I guess I worked as a consultant before getting into my product business. I was consulting for a lawyer who, I was helping him with prior art in the field. And then I had a client who basically paid this lawyer to learn about, you know, my expertise in 3D knitting so he could write them a patent for what we were working on together. So here I have a lawyer who I don't need to pay him to get educated because my client already did that. And I have trust with him and his team because they've hired me several times to consult on prior art. So, I mean, it was kind of like a no-brainer. And like 6 years later, it's an amazing relationship. Like, of all the contractors and third parties I work with, Warner, Norcross, and Judd is my favorite, and I love working with Chad. But I did work with Varnum for a little bit. Shout out to Varnum because you guys have the Michigan Springboard program, and that was really great. And had you happened to have been the lawyer for my client, maybe it would have gone that way. But that for me, it was just the personal connection, and I know you have that in your network. You have personal connections that you can leverage to find the lawyer that fits you.
Yep. Yeah. Exactly right. Yeah, and Warner is a great firm. I mean, they're I don't like them because they're one of our biggest competitors, but they're a great firm, and they're all good lawyers there. So yeah. Shouldn't say I don't like them, but
Yeah, no, I know what you mean. Yeah.
Professional rival.
Right, exactly. Yeah. But yeah, that's a great example. And then last but not least, don't budget for legal fees. Obviously, you should budget something for legal fees when you're putting together kind of your initial budget or go forward budget. Like it or not, attorneys are just kind of a cost of doing business, I think, for if you want to grow and be successful and have a professional enterprise. Some might say they're a necessary evil, but you should plan on spending some money on lawyers. And again, this is not a plug for me. It's just as I'm just trying to give practical advice that you probably will need a lawyer at some point. And paying upfront is a lot easier, even though it's not cheap. It's a lot easier and cheaper than not doing anything and wait. All of a sudden you have a big problem to be cleaned up, and that gets super costly. I just worked with a company last year that actually came in through my Springboard program, and I worked with them for 5 years, and I went through a couple of investment rounds with them. But early on, their cap table was just a complete mess. They'd issued stock options when they were an LLC, and they don't even have stock. And so, what does that mean? There, were owners that had kind of fallen off the map, and so there was a lot of cleanup that needed to be done, and it ended up being costly because the investors are like, well, I'm not going to give you this money until you fix this, and it was something that could have been avoided, had they, had the right advice up front, before they worked with me, of course. But, that's all I have. I know I sped through some of that, but anything I didn't touch on, or any kind of particular stories that you guys want to share, or questions that you have? I can't get into too many specifics about your own business, at least in this kind of forum, but happy to do what I can to help point you in the right direction. Yeah.
I know you touched a little bit on this, and this is a complicated issue, but I'm an LLC. Hold on, I text my husband if we do taxes as a C Corp, or maybe we're C Corp, do taxes as an LLC or something like that. But like, when do you know you're supposed to graduate from LLC to C Corp? Is there a checklist of things? Cause like in my journey to figure this out, there's like no checklist that I can go to reference.
Sure.
Yeah.
I would say unless something is like forcing that to happen, and usually that would be an investor coming in that wants the structure, they want to invest in a different type of entity, that's when you'd have to make the change. There's really not, it's not like the corporate structure gives you any kind of better, sometimes it, maybe looks more sophisticated, I guess, to, you know, institutional type investors, but it's not like that is necessarily the next step for any LLC
Oh, okay,
to
so it
graduate
doesn't,
into that.
it doesn't
Yeah.
offer you tax shelters if you have leftover money at the end of the year, that you're not investing back into the company. It doesn't
No.
give you anything more than an LLC does.
That's right. Yep,
Okay, that makes
exactly
sense.
right. Yeah, so you could, you know, plenty of companies just remain LLCs throughout their whole existence.
Okay.
Yeah.
What's
Being
the-
taxed as an S corp or a C corp lets you save a bit on taxes.
Okay,
as
maybe
well.
that's what I'm doing. I'm not, yeah.
But what was like the trigger point for that? Like at what point does it actually help you?
For me, it
save
was,
taxes?
attorney or tax fees versus, savings.
Yeah, your accountants often recommend
So-
that.
Like when
Yeah.
you do
She-
your taxes, haven't looked at it for years,
Yeah.
ours just switched to us this year.
She said it at like 40 to 60 grand a year, to
Okay.
make that flip, and you can do it at the end of the year for the entire
But
year.
it depends if you have other owners too,
Yeah, yeah.
they're like small.
What's the advantage to an investor if you're a C corp versus an LLC? Why do
That,
they- why do
that
they-
is just, that's the entity that, so when they're making investments, they're just almost across the board. And I'm talking about like bigger kind of institutional type investors, they're, across the board corporations. And that's mostly because of the tax, the tax, well, a couple of different things, mostly because of tax reasons, where they, you know, actually want the corporation to pay all of its own tax. They don't want kind of personal liability for their share of the company's tax
Mhm.
automatically.
Mhm.
And it's just, you know, they usually have their own kind of form documents that they give kind of across the board that are structured for corporations. And they wanna just kind of make it as kind of as cookie cutter of an investment as possible. Also, like I said, you know, where the company is formed, whether it's, usually they're looking for Delaware entities. But most of that is tax driven.
Okay.
Yeah.
That makes sense.
I have a question.
Yeah.
So back to your earlier remarks about an operating agreement between co-founders. And we work with like really like early stage startups, and quite often we'll get a single founder that's like, I need a co-founder, I need a tech co-founder, you know, help me find somebody. They're really just thinking about, you know, helping to create the product or sell the product or whatever the case may be. And then they become co-founders. Sometimes before they even have like an operating agreement. I mean,
No.
is there like a checklist scenario thing of, these are things you have to think about when you're becoming co-founders of, you know, like all the things that could go wrong, all the things that you have to agree on,
Yeah.
things that you should put in an operating agreement.
Yeah, I mean, in that situation, I think,
Successful.
especially if they don't have like a relationship already, like, I think my first instinct would be to say, well, maybe you don't need a co-founder, maybe you need either a financial investor or a consultant, you know, that you can still, if you have, you know, it comes back to money, but if you can avoid giving them equity and, you know, calling them a co-founder up front, that saves you a lot, you know, in terms of structuring the business. A lot of headache or, you know, loss of profits potentially.
Yeah, well, that usually comes into play because they don't have money to pay
Right.
somebody, so that's the solution is we'll share, you know, we'll be co-founders, 50-50 or
Yeah.
whatever.
Yeah.
And that, I think probably the biggest things to think of, it's not, you know, not really a legal consideration, but most of that, what that comes down to is, you know, specifically what the other person has to offer from a technical standpoint or, you know, experience standpoint, and kind of the psychological piece of, can I get along with this person? Can I own a business with this person? Can we, you know, agree on the direction of the business? Which is usually like the bigger issue, you know, that how whether you actually get along with that individual.
Get a date for a while.
Yeah, exactly. Yep, yep.
And then have a prenup.
Right.
Last time I was in last time I was in a 50-50 startup, we had 3 external, like, if I think yes and they think no, there were 3 other external people that could then break the split.
Yep.
I thought that was kind of
like the little board?
Yeah, uh-huh.
Yep,
Yeah.
or an advisory committee or something,
Uh-huh.
yeah, there's a lot of different names, but yeah, I was just talking to a client about that yesterday, actually. That's a common scenario where, especially where it's owned 50-50, with the, you want language in your operating agreement that says, you know, if the business is at an impasse, if we have like a critical business decision, or, you know, we're trying to decide whether to expand and, you know, whatever the decision is, and you can't move forward, there's kind of like this tiered approach where, you resolve that dispute short of having to go to court, right? And because if you don't have a pre-programmed, you know, steps to follow, then that's really is the only option if you can't come to an agreement on your own. And usually that's something like, you know, the founders will talk about, you know, the 50-50 owners, if they can't figure it out in whatever number of days, it goes to an advisory committee. Sometimes they, you know, sometimes that's a binding decision. Sometimes you trust these people enough to actually make that decision for you. Or if you don't have an advisory committee, then kind of the backstop is what we call like a shotgun buyout, or a buy or be bought provision, where one of the members has the contractual ability to say, all right, here's what the company's worth, here's what my 50% or 50% of the company is worth, and then and then you kind of give notice of that, triggering this right of the other member to say, all right, I will buy your equity for that price, or I will sell my equity for that price. So it's kind of like the one partner cuts the candy bar, and then the other partner gets to choose which piece they want, or really it's the whole thing, but gets to choose if they are the buyer or the seller. So it gives the person setting the price incentive to pick something that's fair. And then it gives the ultimate decision to the other party as to, you know, whether they want to stay in the company or buy, you know, find funds to buy out the person. Where that doesn't work is where there's a disparity in, you know, finances, where one is kind of like the rich guy and the other guy is like the poor, you know, founder, because then, you know, the rich guy can set a price that the other guy can never meet. So it's not a slam dunk, but that's usually what we would try to do in any kind of 50-50 owner situation. Any other questions? I'm available. You know, I try to have office hours here more so this year, but I'm scheduling regular kind of office hours here over the coming months, and so I'll be around. You know, this is my contact info, but